This is the American Law Journal.
Despite no act by Congress, no specific ruling by the Supreme Court, is discrimination at work based on LGBT status becoming a thing of the past. Good evening, I'm Christopher Naughton. Welcome to the American Law Journal. Between the EEOC and the latest ruling by the Supreme Court on gay marriage, LGBT rights are growing at the workplace. But what if you are the T in that LGBT equation? Gina Passarella explains.
Are you a woman? That's a very good question. We seem to assume that every person is either a man or a woman. Each person is actually both.
1952. A former GI travels to Denmark for surgery and returns a woman. Curiosity and shock accompany her return. Long before Renee Richards, Chaz Bono, or Caitlyn Jenner, there was Christine Jorgensen, pioneer, social icon. Today, she'd be considered the T in LGBT. Fast forward to 1964. Congress passes the Civil Rights Act. Title VII of the Act prohibits race, sex, and religious discrimination at work. Given the times, on-the-job protections for sexual orientation or gender identity, not even a consideration. But the terrain shifted in the late 1980s. The Supreme Court heard the case of a female executive denied partnership because she was perceived as too aggressive, too macho.
It has been the case since Pricewaterhouse that discrimination on the basis of gender stereotyping was found to be protected by Title VII, but there's numerous court cases that say sexual orientation in and of itself is not protected by Title VII, which lists sex and gender.
A recent EEOC decision, however, may change things. David Baldwin claimed he was not hired as an FAA manager at a Miami airport because he's gay. The Equal Employment Opportunity Commission agreed, calling it sex discrimination, and going where neither Congress nor the Supreme Court had explicitly gone before.
The EEOC ruled in July that discrimination based on sexual orientation falls within the Title VII protections of the Civil Rights Act of 1964.
It is not at all clear to me that the courts are going to accept that leap by the EEOC.
There are some older federal court decisions that went out of their way to tell lesbian, gay, and bisexual employees that they did not have a claim. What that decision says is that you can't consider someone's sexual orientation without considering their sex.
Which may afford more protection for gay and bisexual employees, and clearer guidelines to employers. But what about the T in LGBT?
Because when you say particularly the T, it changes the answer dramatically.
There's not necessarily a really easy answer.
Sir, can you hear me? Because this is the ladies' restroom, and clearly that is a man.
You know, if you have employees who are saying having somebody who looks like a male or we know biologically is a male in the bathroom with us, that is harassing. That's creating a hostile work environment. What do you do in some cases about things like security clearances or training records where people are actually changing names and changing legal identities? Or do you have an obligation during a transition from male to female?
And because Congress and state legislatures are unlikely to act, solutions may come down to city ordinances and company policy.
Most people in the workplace don't want to have a good claim that they can win somewhere down the road. What they want is they want to keep their job. They want to get the job. They want to stay on the job. And employers, many of them, most of them I'd say, are looking to make sure that they've got the best person on the job.
Despite some recent rulings that have advanced the ball on LGBT rights in the workplace, the issue is still a moving target in the courts. So employers have taken it upon themselves to craft policies that work for them and their employees. The questions aren't always easily answered, but the dialogue is happening much more frequently and openly. For the American Law Journal, I'm Gina Passarella.
For guests with me tonight, let's go ahead and meet them. Anthony Howler hails from Blank Rome. He heads up their labor and employment group. He has been described as a preeminent litigator, and I like this. He's also called a calming force in difficult situations. Mary Tiernan joins us once again. She's been with the EEOC since 1991, almost as many years as we've been on the air here at ALJ. Angela Giampolo represents employees in age, race, and sex discrimination matters. She's also an active columnist for Philadelphia Gay News. And Scott Goldshaw is with Salmanson Goldshaw. Scott has more than 17 years in the trenches representing employees and employers, including transgender clients. And there's something about representing that client that really is different than any other, isn't there, Scott?
Yeah, absolutely. One of the first things that comes to mind is that it's an area of the law where you're in the difficult position of having to explain to your client that the law is not very clear, and that it's difficult for a non-lawyer to understand that the law often has gray areas. And we are still in the midst of a period of change where the rights of transgender employees is very much up in the air.
But Angela, haven't transgender employees enjoyed a little bit more rights than even gay employees, because it's a matter of gender? And there it is under Title VII, age, race, sex, gender discrimination.
You could say so, right? Even though there's devastating discrimination that occurs within the trans community at work, and if anything, they tend not to even be employed. Trans people are 4 times more likely to make under $10,000 a year, basically be impoverished, despite being more educated than their straight counterpart. So some say they're not even in the workforce in order to be fired. But to your point, if they are in the workforce, we've had several either Supreme Court cases as well as EEOC decisions come down that give us some teeth, right? And actually give me a hook in order to hang my hat on, to be able to sue. There's still some educating that has to go on there, but ultimately we have something. And here in Pennsylvania, we don't even have that for the LGB. That we have to reach for that.
Anthony, a little sympathy here for the employer. You could be the most progressive, liberal, open-minded employer out there, and yet there are quagmires and traps and challenges that, once again, even the most open-minded employer is going to have to face.
Well, I think that's right, Christopher. I mean, the law has developed in a way that employers must recognize that there are some protections for people who are in the transgender community. So then the question becomes, what must an employer do about it, and how does an employer adapt to having somebody like that in the workforce? And it's very challenging because, first of all, you have employees that may have very different views about the issue and are not necessarily as accepting as employers would want them to be. So there's a great deal of training and education that you need to do if you want to be hospitable. But there are all kinds of issues: restroom issues, dress code issues, medical information, using the right pronoun. And sometimes somebody who's in transition, it can take a very long time. You know, not everybody is like Caitlyn Jenner and has, the money to have an operation that is as swift as it was.
Angela, now you've mentioned something to me that I found fascinating, and this may not be, completely legal. But
yeah, my last name ends in a vowel.
So you can speak with your hands,
exactly.
Like I do too. So you've said that on more than one occasion that there are lots of people in the LGB community who are not necessarily accepting of the T in LGBT. Translate how that might turn into, or the lack of legal rights.
Well, so the only thing I was going to not agree with what Anthony just said was when he said it's very challenging for employers, right? These accommodations, which the ADA it's very challenging. And then he mentioned people's views. And that's not just within the heterosexual community. LGB, also, we have transphobia within the LGB community. I don't know how many times I hear a gay person. I'm a regular on a radio show with 2 gay guys. And they make a commitment to always touch on a trans topic. But then when they do, they end it with, but Ange, I just don't get it. And you have that happening within the LGB, and I just really want to put it out there that if we're going to call it the LGBT fight and the LGBT community, we need to be there for the T the way they've been there for us. Because actually 2 trans people started the fighting at Stonewall. We had 2 drag queens start everything at Stonewall, and now when all is said and done 50 years later, we're not there for them.
So you can understand then if there's misunderstanding in the LGBT community, then heterosexuals, employers, it's going to be rife with confusion. And part of the problem that employers, and you mentioned it a moment ago, Anthony, it's use of pronouns, access to locker rooms and bathrooms. What about how they're identified on their paychecks, on corporate forms? I mean, again, even the employer who wants to do the right thing could step into a minefield here.
Right.
There are obvious pitfalls.
Yeah.
Right now, though, the law is really still, I think, in the position of protecting only the situation where somebody is being treated differently because of a stereotype about how a man should act or a woman should act.
Right.
And while the EEOC has taken a different position, clearly,
Right.
I do not think, and I don't think the courts believe, that transgender status is yet, within the four corners of Title VII of the Civil Rights Act, and therefore a protected group.
Mary, let's go to that EO decision, because again, that sent I don't want to say shockwaves, it certainly has sent waves through the labor and employment community. What came down this past summer?
This summer in the Baldwin decision, we recognized for the first time that discrimination just based on sexual orientation is inherently discrimination based on sex, and it violates Title VII. And there are a few different ways you can look at it. I mean, if you talk about sexual orientation, by nature you're talking about sex. Somebody who's gay is attracted to someone of the same gender. A lesbian is attracted to someone of her gender. A heterosexual is attracted to someone of the opposite gender. You're inherently basing it on sex. Or you could look at it as discrimination based on somebody's association with someone based on sex, or because of stereotypes or assumptions or gender norms that an employer or a decision maker might have. So we're not making a new, protected class. It's still going to discrimination based on sex. And one of the analogies that we had, even though discrimination based on an interracial relationship wasn't a specific basis, EEOC and the courts have recognized for years that if an employer refused to hire somebody because he was in an interracial relationship, or fired someone because she was involved with someone of a different race or had biracial children, that's a straight Title VII violation. So it's the same kind of thought process and analysis that we got to, based on Supreme Court decisions, lower court decisions, looking at how we interpret sex.
This is a situation, Christopher, where we have a government agency that it does not represent the people. They're not elected officials making law, because they are making law. There are 7 Court of Appeals, federal Court of Appeals throughout the country that have dealt with this issue, and all of them have said sexual orientation is not covered by the Civil Rights Act. In 1974, there was an amendment to the Civil Rights Act proposed that has been on the books but never passed, which is ENDA, which is to extend civil rights.
Which I call Splenda.
Right. And so I think it is actually alarming that a federal agency believes that it has the power, arrogates to itself the right to legislate. And though I understand how the extension is made, it is really not the law. There are areas where the law does protect to some degree, not the full extent that I think all of us believe it should. But for an agency to say this is the law, I think is very controversial.
Yeah, and
well,
Mary,
I think we're,
go ahead, Mary.
Thanks.
Go ahead.
But I think it's not that we're making law, we're interpreting the law that Congress charged us to interpret and do investigations on. And some of the court decisions in the past where they were not recognizing that sexual orientation discrimination was covered, some of those types of decisions may have predated the Price Waterhouse and subsequent other lower court and Court of Appeals decisions. I mean, there has been an evolution and a greater understanding of how this falls within sex discrimination. So I don't think it's that we're making new law any more than when we recognize that discrimination because someone's involved in an interracial relationship, we weren't making new law, we were interpreting what we were charged to interpret, what is race discrimination. Same kind of argument, we're interpreting what is sex discrimination. And at the heart of any of our laws is that people should be judged on their ability to do the job.
Okay.
Their experience, not who they are or not who they're attracted to.
Right, but again, there is protection for gender discrimination. That's why I said at the outset, maybe transgenders actually had a bit of a leg up, on folks who are gay. And yet the EEOC comes out and says, well, we're putting sexual orientation more or less into Title VII. I think that's would be Anthony's argument. And if that has happened here, does this affect more than just government employees? This kind of law, this kind of, again, edict, if you will, from the EEOC decision is going to affect the private sector as well, no doubt, right?
Oh, I mean, this is our interpretation. This is not just, in the Baldwin case, it was a federal employee, but it's not just how we're interpreting it for federal employees or applicant for federal employment. If it's somebody working for a private company or state or local government, if they have at least 15 employees, they're covered under Title VII, and these interpretations would apply to them as well.
Let's take a look at Janet Mock. She is a transgender individual who is also an anchor on MSNBC. Listen to what she has to say about the various permutation of sexual identity.
But you're also the face, and a beautiful face, I might add, of the T in LGBT, which is a phrase I hadn't heard maybe 5 years ago. There are 56 gender categories on Facebook.
On Tumblr, there's 1,000.
1,000? I mean, I can't even begin to know what 56 would be.
So, Anthony, you take a look at that, and why would anyone want to be an employer with 50 or more employees?
Well, I think we can boil it down to just respect. At the end of the day, you don't need to know, out of the 64, 63, there's also LGBTQI2SA. I give seminars on it, or keynotes talking about diversity, because we are so diverse. But ultimately, and you can go to OSHA if you don't know how to be respectful. OSHA will teach an employer how to be respectful. The HRC has guidelines on how to deal with employees who are transitioning and sort of, resources. They exist. Employers don't have to figure it out. If OSHA has it, they're not just even LGBT organizations. We have governmental organizations. But one of my favorite books is Everything You Need to Know in Life You Learned in Kindergarten. And really, we can boil this down to that. Self-identity.
But when we talk about Title VII, and again, for those people watching tonight, we've discussed this on this program, you have certain protections at work: age, race, sex, gender, national origin, etc. Most of those, Anthony, as we grew up when we first became law students, were usually tied to immutable characteristics. I know religion is one of the exceptions, but aren't we trending into a territory where we can get to pick and choose what those so-called immutable characteristics are?
Well, I think that is sort of the consequence of what is happening in terms of the development of the law, which isn't necessarily bad. But the problem is that it's a minefield for employers, that many employers that can get into trouble are not the big employers that have lots of resources to do the training and education of themselves and then of their management team and then of the employees, but it's the smaller employers, small businesses, 50 employees, 100 employees, that really don't have the resources and often don't have the professional help to really guide them through these kind of situations. And so I don't think we should underestimate the challenges. And I do come back to the point that it's not simply, we talk very, very often about the employer as if it's sort of one unitary kind of person. But an employer is made up of lots of different people who have their own experiences, their own prejudices, and it's very difficult to manage those when those people and the people running them really don't understand, as I think most people don't, the extent of the variations of gender identity.
I just want to underscore that nobody is getting sued for not using the right pronoun, right? No one is getting sued for saying, I don't know how many people, even colleagues of mine, stumble over LGBT. It's just 4 letters. And it's been used for 20 some odd years.
Couldn't that be the basis of a hostile working environment if someone's not using the right pronoun?
It comes down to intent. I mean, I was in a case where I had to object over 50 times to opposing counsel using the wrong pronoun purposefully. So it just gets obvious after a certain point.
It's court of law.
But there's a recent case where there was a woman who sued because she claimed she had certain religious beliefs in which she was not going to be in the same bathroom with somebody who was a man, it was now female. So she sued the employer on that basis because they were allowing, as guidance would say you do, that the person who was transgender to use the opposite sex bathroom. So I think employers are in a vice here.
Let's not forget that shortly after passage of Title VII in the 1960s, there were also objections by employees to sharing restrooms based on race, and some of those objections were also religiously based. Looking back on it now, we find those arguments preposterous.
That's true. Well, let's take a look at this woman, Rachel Dolezal. She is a U.S. civil rights activist and claims she was an African American until her parents outed her. I mean, if we have that much choice over which protected class we would like to be in, does that not produce a great degree of uncertainty for the employer, even again, if they're the most progressive of employers?
That begs to, it's a moving target on both sides, right? If it's a moving target for you, then it's a moving target for the employee as well. It's not fun to not know when you go to work whether or not you're going to be protected, what state you're in, what municipality you're in. You know, marriage, or the issue of gay marriage, really is a privilege. Not everyone wants to get married. But unless you're a trust fund baby, 99.99% of people have to go to work. So this is really, we're talking Maslow's hierarchy of needs. I empathize. I do. I empathize with the employers and the fact that it's a moving target. And as Scott mentioned, the law is evolving, and nobody can pinpoint. But similarly, there needs to be empathy on the employee side. 91% of trans people report being discriminated at work. 43% of that leads to leaving the job out of pure embarrassment, because especially when they begin transitioning, they may not even come close to looking like the gender that they identify with. And how embarrassing is that to then walk into a woman's restroom? So a lot of them even leave work on their own volition just out of pure psychological distress with what they're going through. So I truly empathize with both sides, but
do we talk about reasonable accommodation here, not unlike with the Americans with Disabilities Act, Anthony?
Well, there is an aspect to that, because if you see how the law is developing, then there are affirmative obligations on the employer to do things, such as, you know, maybe have a unisex bathroom, or to make sure that you have the right kind of dress code in a way that you wouldn't otherwise have to do.
We've made reference a couple times to the uncertainty in the law creating a legal minefield. And to some degree that may be true, but let's keep in mind that it's a minefield that's very easy to navigate. Over 95% of the time, if employers simply base employment decisions on criteria that are relevant to the job, and they treat all employees with respect and dignity in the workplace, that accounts for the overwhelming majority of legal issues that could arise. It's really only some of the fringe issues we've been talking about, such as the bathroom issue, that are not avoided by applying those simple criteria.
I think I agree with a lot of what Scott said, and I think if it's employers take advantage of resources we have on our website, we try to make questions and answers available that employers might have about these coverage issues, how to comply with the law, so we try to do that technical assistance. It might take us a little bit of time, but I think we'll look back on this like, well, of course employees who are transgender would get the same protections, and of course they shouldn't be denied the right to a bathroom, just like looking back, like Scott and the analogies we were giving. We wouldn't say, well, somebody who's of a different race shouldn't use the same bathroom, just because coworkers might be uncomfortable. We think that's absurd now, thankfully. So I think as employers do education and have training with their employees and take advantage of resources in their organizations as well that are out there that would help navigate these issues, I think that it'll be easier. And the heart of it is that treat people with respect. Don't make employment decisions based on sex, just like you wouldn't make employment decisions based on race or age. Everything should be on the person's ability to do the job or his or her qualifications, not who they are, not their gender.
I think some of these unknowns are not that hard to figure out either. If an employee notifies the employer of their transgender status or that they're transitioning, keep in mind that most transgender people want to work. They want to be treated like regular employees. They want to do their job. And if an employer is uncertain, the employer can tap into the vast resources for education, but can also say to the employee in a respectful way, this is a new situation for me. I'd like to handle it with respect. Can we have a conversation so I can make sure that I'm thinking through all the ways I need to be respectful, which will in fact benefit the employer not just by avoiding legal issues, but enable the employer to have a happier, more productive employee who's comfortable in the work environment.
We are so behind. We are so behind. If you actually look around at other countries, trans isn't even an issue. Remember when women could be in the military? Oh my God, this is going to cost millions. Bunkers, where are we going to put them? Oh, Jesus. And now Canada, 10 years, trans people in the military, and they've been figuring it out, and all is well in the world.
And that's why Congress is never going to pass ENTA. Pennsylvania is never going to pass the Senate Bill 300 or the House Bill 300. So municipalities and corporations are going to get there, and by the time the Senate gets there or Pennsylvania's either chamber gets there, the game's going to be over. What if they gave a war and nobody came? By the time they get there, it's done.
Well, I do think corporate America is ahead of this issue, ahead of the courts and ahead of Congress. And I think most Fortune 100, Fortune 500, Fortune 1000 companies have policies that prohibit discrimination on the basis of sexual orientation and gender identity.
And we were talking about catching up with state and local governments. I mean, in a lot of your viewage coverage area, you have coverage already for LGBT explicitly in the city ordinance in Philadelphia. You have it in New Jersey. You have it in Delaware. So a lot of employers have already had these obligations even before EEOC recognized that it's covered under Title VII.
Right. The legislatures are going to get to it last. Let me go around the horn here, and I just would like to get some feedback. Again, it's a little crystal ball gazing. What do you think the courts are going to do with this latest EEO decision? Because this isn't over yet.
Unless and until Congress acts, the EEOC does not have the ability to pass legislation, which is what the EEOC is doing. And by the way, the EEOC there's an executive order, 11478, which they could have relied on, but they didn't. And they didn't rely on it because that covers and protects people in the federal government from gender identity and sexual orientation discrimination. The EEOC wanted to make law, they wanted to influence the courts, but I don't think the courts are going to be influenced. I think they're going to make the decision based upon
plain reading of Title VII. Gotcha.
I think the courts will be split according to how the courts typically fall down the red-blue, but more so than that, and I think a lot of people, LGBT advocates, this is my Philly gay lawyer hat speaking, is that while it may have been reaching and maybe interpreting or over-interpreting or at least reaching, the EEOC decision will still have far-reaching implications because while ENDA has been sitting there for 40 years, as these cases start coming down and the legal quagmire all over the United States is different, someone will have to act. And whether it's one of these cases goes up to the Supreme Court and or Congress acts, but the wheel is now in motion, and that's what this case has done.
Mary, this goes to the Supreme Court. What happens?
Well, I would hope they would follow the statutory interpretation that EEOC says that it's covered, because some of that is based on prior Supreme Court decisions. We were looking at Price Waterhouse and the Uncall decision, recognizing that the evils being addressed by a statute might go beyond the initial language of the statute to achieve their civil rights purposes. And I think that the courts, I think many will follow this because our recognition was based on looking at some of the lower court decisions and Court of Appeal decisions. Some of them are already there, and that was one of the reasons when we were coming forward in our guidance, we cited to those and relied on those.
And Scott, how will this impact your practice moving forward, especially if this kind of a case goes before a judge?
Well, I think that the weight of the case law has certainly been against recognition of same-sex sexual orientation discrimination, as Anthony has said, but I don't think that the law has been resolved with the level of finality that forecloses arguments in the future. The Supreme Court has not ruled, and in those jurisdictions where the decisions are still percolating more, I think the EEOC's decisions will aid lawyers in making arguments, not only because the EEOC is the federal agency charged with interpretation and enforcement of the law, which makes its decisions persuasive, but also because the opinions themselves happen to be particularly thorough and well-reasoned, which will help persuade courts that have not yet reached the decisions.
Let's put it this way. It's never boring with this crowd. I want to thank my four guests. Anthony Haller, hailing from Blank Rome, representing the corporations in labor and employment matters. Mary Tiernan with the EEOC since 1991. Angela Giampolo with the Giampolo Law Group in Center City, Philadelphia. And Scott Goldshaw with Salmanson and Goldshaw in the city of brotherly love. And for all of us here at the American Law Journal, thank you for joining us this week. Till next Monday night, case closed.